Good morning, everyone. My name is Arjan Geveke. I work for the Department of Business, Energy and Industrial Strategy. Not the Brexit department, but I'm going to give a presentation about Brexit and particularly the measures you may be able to take to mitigate some of the consequences of Brexit. So there I mentioned Brexit 3 times in one sentence, just to make up for it in the beginning. Normally I work on energy and climate change policy for my department with a particular emphasis on energy-intensive industries, hence the paper sector, which is one of those energy-intensive industries. But because of the whole campaign and Brexit, basically all the officials who have a closer relationship with one of the industrial sectors or other one of the business sectors in the UK do focus more on Brexit and go out and give presentations about the potential consequences of Brexit and what steps we think that these businesses can take to mitigate some of the risk of Brexit. So Andrew's presentation was mainly on the risks. My presentation will go more into basically the information that we've set out as government basically to help you to mitigate some of the risks that are involved in Brexit. See if this works this time? It does. So key point, the same thing, business should prepare for Brexit. As the legal position remains that the UK will leave the EU by the end of this month, I'm going to highlight a little bit on the explanation of the Ben Act that basically asked the Prime Minister to write to the European Union in case there is no deal at the outcome of the upcoming EU Council conclusions. The thing is, if the Council doesn't give an extension, then the default position is still that the UK will leave the EU by the end of this month. So that's the legal default is basically that the UK will leave the EU by the end of this month. As mentioned by Andrew, Brexit will have immediate consequences for your business and trade operations, and we do encourage you to understand the potential consequences for that. So what I would like to go to basically is the identifies which area you may have to act, focus on key areas and actions you should consider taking, and signposting sources of advice. So it's basically similar to what Andrew already set up. Of course, as civil servants, we analyzed basically which areas are mostly impacted by Brexit. This is a similar topics that were in Andrew's slides, but it goes to importing and transport, energy, climate change, EU citizens, funding, all the way to public procurement. There's quite a lot of all of this, and I don't need to cover it all. I just tend to focus on the key things that are probably most important for you, which are these: logistics, food and drink, employing EU citizens, and using personal data. I'm going to leave out customs, the whole debate about tariffs, VAT, and rules of origin. Andrew already has touched on that slightly, and it will take up a very long time to just scratch the furnace of a bit basically of this of the custom stuff. Instead, haulage gets more complex. It gets complex really quickly if you dive into all those individual policy areas. But on haulage, basically, you need to understand the following. So, if you have goods coming in of trade with the EU and use a haulier, basically, they need to have a right to operate. They have to have an operating license, basically. Now, up to a point, standard international operating license for journalists to and from the EU are necessary, but as well an EU community license and needs to be obtained. And if you don't already have them, the current arrangement will stay in place until the 31st of December 2019, even if there's a no-deal Brexit. After that, it becomes a lot more uncertain. What hauliers also have to have is the right permits. I've listed them over here. European Conference of Ministers of Transport. Basically, if you trade with those countries that are not immediately in the EU, but you're passing through one of those countries in the EEA or EU. And all this is a case of no-deal Brexit. Again, my point as well, check the updates that the government publishes online regularly if we have new information. Additionally, there's a thing called cabotage, basically, where you trade or you use a haulier that goes from point A to B in an EU member state that's not your member state. There are particular rules around that as well. So the number of these cabotage and cross-trade jobs will reduce if there's a no-deal Brexit. Again, until the 31st of December 2019, it will stay the same, up to a point, although because you can carry less cabotage journeys in that period. From the 1st of January 2020, in case of a no-deal Brexit, again, it's uncertain and you have to check basically the government website what arrangements there will be. In addition to that, hauliers need to register their vehicle license, carry vehicle registration documents, and check their their vehicle and trailer insurance as well. Again, most of the information you can find on the gov.uk website and the guidance on all of this. So that's on logistics. On the food and drink sector, Andrew touched on the major risk, particularly with the downstreams, basically the companies that, if you have food and drink companies in your customer base, they may get impacted by Brexit. And one thing, the few things I want to touch upon over here, which I got from my DEFRA colleagues, is the direct impact on organic food and feed sectors. So UK organic producers will not be able to export organically certified products to the EU unless the UK receives recognition from the EU, and that's not the case at the moment. UK organic producers must not use the EU organic logo and any UK organic food or feed unless there is a UK and EU equivalence reached in negotiations. Thirdly, the UK will continue to recognize EU organics and has proposed that no additional checks are required from EU organic food. So that goes one way. How the EU will react to that, that's uncertain, but they will treat the UK as a third-part country, basically, if it definitely comes to a no-deal scenario. There's all the debate about geographical indications, so-called GI, so protected areas where food comes from. This needs to change as well. It will have immediate effect in case of a no-deal Brexit. New logos will be UK-produced food and drinks products with GI protection will automatically transfer to some kind of domestic scheme. And new logos will be available for products protected under these schemes, but it will take some time to implement all of these. So this has an impact on the labeling stuff of products, basically, particularly that have food origins. On food labeling changes after the EU. This will change as well. The level of information on a label will remain the same, but some labels will need to change for some food and drink products. There is a 21-month transition period for labeling changes after Brexit. And in this case, if the UK exits the EU without a deal, the following changes will take effect immediately. So country of origin labeling, it will inaccurate to label UK food as EU origin, so that needs to change. The EU organic logo belongs to the EU Commission and cannot be used in the UK organic produce. See the previous slide. And the EU emblem must not be placed on UK product goods except where the ongoing use of the emblem has been authorized by the EU. So these are immediate changes. Now then you think things through what kind of products or food labeling are in transit. Those will continue. They can continue to access the EU market if they're already in transit or in the process being exported to the EU. So this will start to apply only when you have new products that you want to export to the EU. Again, further information on gov.uk website. On employees, this is probably the area I happen to know the best, being an EU national working for the UK government. I've actually read the most of the provisions in the withdrawal agreement, and basically this agreement follows that up. So the UK will develop its own immigration policy. And it's basically that ends the freedom of movement, so that EU nationals and UK nationals cannot simply move from the EU and back to the UK and the other way around. This means that EU citizens will need to check which measures are needed to stay in the UK. Basically, what I have to do, I need to apply for so-called settled status. But it's the individual responsibility to apply for that. It's not the responsibility of the employer, but we should advise basically that companies help their EU nationals to go through this kind of process. To be honest, in theory, it's fairly simple. You hear some kind of media stories about the complexity of it, but in my case, it's very simple. I need to prove my identity, which I can do with my passport. I need to show that I've been living in the UK for 5 years or more, which will make, basically HMRC will make a link to my tax payments, and they're going to have a criminal record check in case I've killed anyone. Basically, that's it. If I pass all these 3 tests, basically not killing anyone, but if I pass all these tests, basically then I'm in. But it gets complex quicker if you have kind of unique family circumstances. Anyway, the government has published a employees toolkit to help companies support their EU staff. EU, EEA, or Swiss citizens living in the UK should check that and can get more information from Gov.uk. Basically advice on how to apply for an EU settlement scheme to continue living after the UK and after the 31st of June 2021. And check the Commission to see if the qualifications get recognized as well. Again, it normally goes back to Gov.uk. We've published quite a lot of information on this website, and if I can help you find it, but there's a lot of information that I would encourage you to read and potentially to act on. So visit UK Information and Employment Checks. Ensuring you check job applicants' right to work is the same as it is now. And I'm going to just highlight the duty as well, not to discriminate against EU, EA or Swiss citizens under UK law. Let's see. One more thing on employees. There will be a transition period. EEA citizens arriving in the UK to visit up to 3 months will not see any changes. They will not require a visa. So that's normally established international practice, basically. When you go on a visit as a tourist and you leave again within 3 months, that will stay the same. EEA citizen, EU citizen who wish to stay in the UK for longer than 3 months will need to make an application within this time in order to do so. So that requires a visum, basically, which may cause some issues. For example, if you have a project that takes, where you need to draft in, for example, colleagues from overseas to help with that project, it takes longer than 3 months, then that requires a visa. If you want to stay longer than 1.5 years, I think from the top of my head, then you have to go for a temporary residency permit. What this means for business, employers do not have to differentiate between those who are resident in the UK before exit and those who arrive afterwards. So there's not a lot of change at the moment. We just encourage the companies that if you have EU staff employed, encourage them to apply for settled status. Finally, at this point, using and transferring data, that's an issue that's relatively new on our to-do list as well as civil servants. And that's cropped up because we have the GDPR, which I assume you're all familiar with, but it has changes, will require changes as well. Not obvious, but it basically applies to personal data that's held in the EU, and if you want to transfer that to the UK. Not the other way around, because the UK recognizes basically how the EU has handled it, but the EU will start to apply the restrictions under the GDPR for transfers transfer of personal data to outside countries, third-party countries like the UK in case of a no-deal Brexit. This requires some changes to contracts you may have in place that manage basically data flows. So I would encourage you to have a look at that as well. You may have to involve your lawyers, but your lawyers should be able to tell you what the contract provisions you need to change to continue to be compliant with EU data law. So what does it mean for UK business? UK and EU organizations will need to ensure that their data transfers are lawful through a couple of additional steps. And again, you can find out more information on this on the gov.uk website. So finally, Andrew sent the hyperlinks. I'm just going to put on the icons over here, basically. This sets out the main pages to the guidance. There's a step-by-step guidance for business in key areas, so you can focus on the key areas you're most concerned with, which will then give you the links to the relevant guidance. And we have provided tools as well, which hopefully can help basically to help you to take steps to mitigate the risks that come from Brexit. That's it. Thank you.